Good morning. I'm Paul Truster, a program planning lawyer for the Law Society's Department of Continuing Legal Education, and on behalf of the department, I'd like to welcome you all to this morning's program, Hot Topics in Human Rights. Before we begin, the Law Society wishes to bring you up to date on the issue of articling positions for 1994 graduates, and it's a measure of the importance of this issue to convocation that the Canadian Bar Association Ontario, Advocate Society, and other providers have also agreed to provide similar updates at the beginning of their programs as well. As you probably know, the Society has undertaken various initiatives in an effort to address the current insufficiency of articling positions for 1994 law school graduates. It's ironic because limited enrollments and tough competition for law school entry have combined to produce what are arguably some of the highest caliber law graduates in Ontario history. However, economic conditions have caused a decline in the number of articling positions available across the province, and as a result, a number of highly qualified students are without articles as they complete Phase 1 of the bar admissions course. In January of this year, the Law Society was aware of 217 students in third-year law school who had not yet secured articles. The comparable figure for 1993 was 155 students. 217 represents 17% of the incoming bar admission course class, and the number has been reduced only slightly over the last few months. The current estimate of the number of students that continue to seek articles is 175, or 14% of the class. If you have an articling student, the Law Society urges you to consider taking another student or students. If you do not have an articling student, the Society asks that you seriously consider hiring one. Although the majority of students are placed for a period of 12 consecutive months with one employer, joint articles and part-time articles are relatively recent features of the articling program which do create the opportunity for new articling placements. In joint articles, a student has 2 or more articling principals during the 12-month term, either consecutively or concurrently. This program is particularly suited to the lawyer with a peak business period who can employ a student for 4, 6, or 8 months, as well as the lawyer who may need assistance only 3 or 4 days per week. Sole practitioners and others who have not hired a student in the past should consider meeting their support needs through the articling program. As well, some students are looking for part-time articles, often due to family responsibilities. A few lawyers have expressed concern that the unplaced students are somehow less qualified, allegedly having lower academic averages or other attributes which may make them less attractive candidates. In fact, nothing could be further from the truth. A review of the resumes of the unplaced students reveals that the majority have a B average in law school and that the group includes students from each of Ontario's law schools. Many of the students possess language and computer skills as well as work and other experience which demonstrates their ability to work cooperatively and effectively with a wide range of individuals and groups. To address another commonly expressed concern, articling salaries are reflective of current economic conditions. Students provide a cost-effective way of providing support to lawyers in a wide variety of legal tasks and enhance the quality of service which the lawyer can provide to clients. If you can help in any way with the placement of one of these highly qualified students, or if you'd like more specific information about this initiative, we urge you to contact Mimi Hart, the Director of Placement for the Law Society, at 416-947-3420. We have some articling placement registration forms, which you may have seen at the registration desk. They're available for pickup there during the break and after the program. We should emphasize there's no obligation in listing a potential articling vacancy with the placement service. If you do not find a suitable student, you merely withdraw your listing. However, recent experience indicates that this will likely not be the case. The majority of lawyers listing with the service do hire a student and comment favorably on the quality of applicants, often indicating they wish they could hire more than one. As you know, articling is a fundamental part of the education of the lawyer. The Law Society believes the profession has a moral obligation to assist those who come after us to complete their legal training. Please take this issue back to your office and consider how you can help. The Law Society strongly encourages you to be a part of this important effort, and thanks you. Turning back to our program, I'd like to begin by welcoming today's faculty, not all of whom are as yet visibly in place, but as you know, the Law Society's CLE program is completely dependent on the efforts of volunteer faculty. They've given very generously of their time and talents, both in preparing today's program and in presenting it, and we're certainly very grateful to all of them. No further ado, I will introduce the morning's chairs. Lynn Bevan is counsel to Stringer Brisbane Humphrey, Toronto, where she specializes in employment equity, pay equity, and internal human rights investigations and mediations. Jeffrey Sack, QC, is partner in the law firm of Sack, Goldblatt, Mitchell in Toronto. He's active as counsel for labor and professional organizations, appearing most recently in a number of major cases involving the Charter of Rights. And both chairs are doubtless already well known to you as the authors of numerous works in the labor and employment field. Please join me in welcoming our chairs. Thank you.
We have a very tight schedule today, so I'm going to briefly outline how we're going to stick to it. Today, as you can see from the agenda, we will have first a presentation by a speaker who's also prepared a paper which is part of your materials. After that, a panel consisting of different people in each case for one of the participants on the panel. For this panel, we have Roy Filion, will answer a series of questions. Following that, there will be opportunity to receive questions from the participants here today. So rather than taking much more time on that, I'd like to tell you what the theme of today's program is. I believe you will see this as the day progresses. The current word in human rights is due diligence. Due diligence is not unique by any means to human rights law, but it pervades it. Due diligence requires organizations to take steps to train its supervisors and managers to respond to discrimination. Furthermore, it requires education of all employees in human rights, health and safety matters, and any other matter which affects the well-being of employees in the workplace, and in some cases outside the usually understood workplace. It also requires organizations, both union and management, to have a strategy to respond and monitor. What is due diligence? You will hear it over and over again. It means having in place a policy, a procedure, and a monitoring system. And today, throughout the first panel on workplace harassment, the second panel on drug testing, and the third panel on accommodation, you will hear this theme repeated. What has changed, I suppose, the best way to put it, is it's no longer satisfactory to respond. This has been the case for some time. But now I think we have a much greater understanding that organizations, and in most cases unions, must take proactive steps to prevent the occurrence of discrimination, prevent the occurrence of health and safety problems emerging in the workplace. The failure to do so can result in personal liability for individuals as well as organizations and unions. It can also result in multiple proceedings in the form of civil actions, grievances, and human rights complaints. What you will hear today from our speakers and our panels is just how far-reaching are these duties. Furthermore, these duties are expanding and changing. The purpose of the session is to identify the hot topics and to hear what are the interests of the three workplace parties, the employer, the union, and the individual employee. And to start us on this theme, I would like to introduce Barbara Humphrey, who will address the challenge of workplace harassment issues. Thank you.
Thank you, Lynn. Not surprisingly, it will be impossible for me in the 20 minutes, maybe down to 15 now if I want to keep Lynn on her schedule and Jeffrey, to provide you with any detailed appreciation of all of the issues relevant to workplace harassment. But I do encourage you to read the quite lengthy paper I've provided you with. It's an attempt to start your educational curve in terms of these complex issues and expanding issues. In that paper, I've provided you with the legal framework, analysis of the legal framework that governs workplace harassment issues. Focused your attention on the variety of roles that counsel plays. It's rather unique in terms of human rights, and particularly workplace harassment issues. Counsel has a number of roles: educator, litigator, implementer of policies, mediator, and I think you'll find the paper interesting in terms of outlining those potential roles that you will play at different points. Then I've also focused in the paper on what I've identified as key issues that if you're going to be counsel in the context of human rights issues, workplace harassment issues, that it will be useful for you to identify at this point. What I do propose to do in the brief time this morning is to highlight for you some of these key issues and in very brief terms, and that my comments will be expanded upon by the paper when you review it. First, in the context of due diligence, it's important to appreciate in very practical terms the scope of the duty to act in the context of workplace harassment issues that arises out of the due diligence obligation. And a preconditioned understanding the scope of this duty to act is understanding the underpinnings of due diligence. And what those underpinnings are in the context of workplace harassment issues are that, starting with the Robichaud case, but it's a position that's been adopted and has been attractive throughout all the jurisdictions in Canada, has been a recognition that employers and directing minds, and a directing mind is anyone who, from a supervisor above, holds any managerial responsibility. And recently, an acknowledgement that union officials, given the position of authority in the workplace, would also be part of this group of directing minds. A recognition that as a matter of policy, they're the people with the authority and the resources to stop workplace harassment. And therefore, they're going to be held liable unless they're duly diligent in stopping it. Now, in practical terms, what that translates into in terms of the duty to act is, first of all, an obligation to take proactive steps, even in the absence of a specific harassment issue or concern being raised. An obligation by employers to take proactive steps to ensure that they don't have the problem. And that means an effectively drafted, effectively implemented policy, effective training at all levels of the workplace in their responsibilities and obligations. And those vary depending upon the role you play, particularly the distinction between a directing mind. Effective monitoring systems, including advisors for informal resolution, including an internal complaints process. And you'll see in the paper elaborated on that idea, and quite frankly, it's certainly a role of counsel. I probably spend 70 to 80 days a year with employers now, developing, implementing those policies, training their staff, training investigators and advisors, and it's a role. There is a legalistic base to these obligations, and there's a role for counsel that is one that you should be aware of. Now, in the context of specific harassment issues, meaning when an issue is raised, there's also an obligation to act in terms of whatever information, if any information comes to the attention of one of these directing minds, that on a proper appreciation of that information would in fact be a harassment issue or concern. And this, it doesn't require that you receive a complaint. It doesn't require that someone, raise a complaint. It means, however that information came to your attention, doesn't require that you understand the legal significance of it as a directing mind. You have an obligation to act, and I'll say just act at the moment. The appropriate act will depend on the quality of the act and what's required to deal with it effectively and required from a due diligence perspective. The significance of that is that it's important to avoid directing minds finding themselves with liabilities that they understand, have a full appreciation of what workplace harassment is, because obviously you can't act if you don't know what you're confronted with. And it's very rare. I've been involved in a case in the last 15 years where it's not a common response of someone who finds himself on the wrong end of a harassment complaint, whether it be a directing mind or another perpetrator, of saying, well, I had no idea that this act was this problem. Now, that's all I want to say at the moment on the due diligence in terms of some practical comments. The next area I'd like to highlight for you, some issues which I'll call disclosure issues. There are a number of disclosure issues that are important for counsel to appreciate, and in two contexts. One context I'd like to address first is the context of when you're involved in formal commission compliance processes, meaning where there's been a formal complaint to Ontario Human Rights Commission, could be the Canada Human Rights Commission. And there are three disclosure issues I'd like to address in that context. The first one, which maybe isn't entirely accurate to say it's disclosure, but I think it's close enough to put under this bundle, is the importance of counsel conducting a prompt and thorough investigation and taking very detailed statements when a complaint is first received. There can be a tendency to, when a complaint's received, the first job of counsel with their clients is to prepare a reply. and there could be a tendency to focus narrowly on just responding to that reply and somewhat economical in that reply. It's critical that counsel do a complete and exhaustive investigation, or depending on the size of the organization, if they have, under your guidance, if they have sophisticated HR people to do it, for a number of reasons. First of all, it's necessary for cost-effective resolution of the matter. If you don't do a complete investigation at the point that you receive the complaint, you're not in a position to assess whether or not your client's at risk. And based on my experience, in vast majority of cases, they are at risk, meaning there is some liability that's going to arise out of the human rights complaint. And therefore, you want to be able to assess that early on, because it's going to be in their interest that you then move into a settlement mode and resolve the matter as quickly as possible. You will have much more flexibility in achieving a resolution that meets the interest of your client and, quite frankly, the interest of that complainant, who may otherwise have to wait 3 or 4 years. Whether your client's the complainant or the respondent, corporation or individuals, if you assess it in a timely manner and respond appropriately in terms of your settlement initiatives. The second reason, and really related to the first, is the lengthy delays in the Ontario Human Rights Commission process. What happens right now if I file a reply on behalf of a client, I know, I can guarantee you, the first word I'm going to hear from the Commission is going to be at least a year later. There is a backlog of cases. That means the cases are simply filed away once a reply is filed, assigned to an officer under the case management program when they have the time, and in most areas in Ontario right now, that is a year later. Can be longer, but at least a year later. Even then, it's usually another year, can be longer, with several changes of officers not being unusual before an investigation is complete. The problem there is that in order to secure and preserve the evidence relevant to the complaint for your client, particularly if your client's the respondents, corporate or otherwise, it's essential that you do the investigation at the time, that you don't wait and monitor and do it at the time the officer does, because that's going to be likely 2 to 3 years later. Third reason for this prompt and thorough investigation is because of a disclosure problem that you're going to be faced with in dealing with the Commission and in relying on the Commission's officers' investigation. That arises out of several features of the Commission processes. One is that there are limits on the role of respondent counsel in terms of being a participant in the investigation. They will not allow you to be present for the interviews of anyone other than the directing minds. However, the way around that is you just make sure that you interview everyone they do. I tend to take a very cooperative approach with them, even want to set up the time and the place for the interviews so that you know who they're interviewing, and though you can't be present at the same time, at least you're interviewing the same people contemporaneous in terms of time. In addition to the limits on the investigation process of your involvement, they will resist any disclosure historically. Now, maybe this is going to change in light of a recent case I'll tell you about, but they historically would resist any disclosure of their case other than this case analysis or case summary that you will receive at the end of the investigation. There's a great continuum of quality and of detail in that case summary and case analysis, depending on the quality or perhaps depending on the energy of the officer involved. It's usually not, shall we say, adequate in terms of providing you with the information you need to know about the case you're faced with for a board of inquiry or tribunal hearing. And therefore, another reason for focusing on the need for your thorough investigation on your own at an early stage. In terms of a second disclosure issue, in the context of filing a reply, the complaint may be accompanied by an additional request for information or documents aside from the substance of the complaint. And it's important that you assess the significance of that in additional information documentation early on, because if it's supportive and useful in terms of your client's case, then fine, spill it all out. If it isn't supportive and it's problematic, I found that the officers aren't too diligent about what's on that third page, what additional documents, and it's very easy to strategically feed it to them at your pace or not feed it to them prior to having an opportunity to resolve the matter. So I just note that it's important to consider the details being requested and consider a strategy for how and when you're going to provide those. Keeping in mind they do have a legal entitlement to them. Thirdly, in the context of securing sufficient information to properly prepare for litigation if a board of inquiry is appointed. I've commented historically on this no disclosure approach of the Commission. Good news is a recent case, Northwest General Hospital, where an employer successfully brought a motion to a board of inquiry saying we need disclosure of the Commission's case to properly prepare for the board of inquiry proceeding. And the board found that it was not covered by any privilege, that the interest of fairness demanded they have it, and that it was not information that the fruits of an investigation were not information that was in contemplation of litigation. They separated the investigation stage from the litigation stage, which is after a board of inquiry is appointed. So as a practical tip, I suggest that given that case, we all take advantage of it. And whenever a board of inquiry is appointed now, my first letter to the board of inquiry and the Commission is demanding full disclosure in accordance with the Northwestern case. And I anticipate we're going to be resisted every step of the way by the Commission. But let me move away from disclosure issues to multiple proceedings, and I'm really running out of time. She must have shortened me too. Multiple proceedings issue. Just note, and I've elaborated on this in my paper, but it's not unusual at all that in the context of harassment issues, you may be faced with multiple proceedings, either a victim of harassment who leaves her job and then files a human rights complaint as well as a civil action for constructive dismissal, or victim of discrimination and harassment who happens to be a member of a bargaining unit who files a human rights complaint and files a grievance. And let me comment briefly on the multiple proceeding issue with both of those. In terms of the civil suit human rights complaint, the historical approach of the courts has been, by and large, to grant a stay. And the basis has been a reflection of concerns with inconsistent fact findings, inconsistent damage assessments, inconsistent remedial principles. However, and I don't know if it's an aberration, but take note for those who want to steer things in the other direction, there is a new approach reflected in Lehman and Davis case, and the details of that are in my paper, where they did refuse to grant a stay. The court's feeling was that the concern for differential remedy could be dealt with in the context of counsel's argument, and they were more concerned with the overriding concern was timely justice as a result of the protracted delays in human rights processes. And those are certainly well documented and maybe will lead to that not being an isolated case. Wind down, okay. Remedial powers, just briefly. Keep in mind, this is dealt with in the paper. The remedial powers are very broad under the Ontario Human Rights Commission and under the Federal Human Rights Act. Under the Ontario, to do anything. That's the language in the statute, to do anything, and it means to do anything. Note that the Commission is taking an increasingly focusing on broader systemic remedies, which result in more intrusive remedies in the workplace. Another impetus to be proactively dealing with these issues internally. Restitution, note, no reasonableness qualifier in terms of foreseeability of damages. You take your victim as you find them, and there's an increasingly broad approach taken in terms of financial terms to make a victim whole. General damages, which have nothing to do with any real economic loss, the cap is currently $10,000. The key thing, though, is what the Commission is doing with those powers is increasingly, I think, the most concerning to employers and creating the impetus to deal with them proactively yourself is what they're doing with this to do anything and this concern with the broader workplace environment. Ongoing monitoring, we want to know names, address, phone number of every woman you hire, fire, promote, demote for the next 2 years, or any visible minority, because we're going to monitor how you treat people. Finally, settlements, stop now. I'm not going to stop because I know it's not been 20 minutes. I'm just going to tell them about settlements, and then it'll take me 30 seconds. Settlements, very important. Get a release. The Ontario government didn't get one from Colin Masters, and don't ask me why not, but do get a release if you're going to settle these matters. Just as important, the Gag Clause Issue. I'm sure anyone who's dealt with the Commission has run into this. When you're settling a human rights complaint, Commission's position is we will not give you any gag clauses. We will not agree to any confidentiality because we want to use these settlements to blast over the press because that's how we educate people. That's always escaped my, my limited abilities to understand how that educates people. And it's not punitive, of course. But do recognize that this issue comes up every time you make a settlement. You have to make an assessment of whether or not, and you make them all the time, the interest of the client in settling versus the likelihood it'll be published. the likelihood is the lower the settlement, the less the profile of the client, it won't be published, and I take those chances all the time, and they're not published. If you're dealing with big bucks, though, or a client with a high profile, then you're going to have to find a way around it. One I found works, I don't know if it'll work again, is if they've got their own counsel, then you and the counsel settle it quietly. Part of the agreement is it's withdrawn from the commission, and they never know the terms of that settlement. Risk is they have the right to proceed with a complaint in the absence of a complainant. Practical reality is they've got so much work, they don't need to go looking for work. So it's very unlikely that they're going to proceed in the absence of a complainant. Thank you, and hopefully my paper will add to the comments I made today.
First of all, I want to congratulate Barbara for sticking to a very tight timetable. Barbara will now join us on a panel, and I'm going to pose a series of questions to Jeff, Roy, and Barbara. There will be a very brief response to the few questions that we have by necessity. And of course, again, I just note that we really welcome your questions at the conclusion of this panel discussion. The first question is a practical one, and that is the question of what a union should do if approached by a victim or by an alleged harasser, and of course the flip side of that, what should an employer do if approached by a victim or an alleged harasser? And I'm going to start by asking Jeff at the far end for his response.
Well, thanks, Lynn. I think the first thing you do is you determine whether you are acting or you are receiving in your office the victim or the harasser. If you are acting for a union, you may in fact be representing either one. In my office, lawyers may on any given day be representing the victim, or they may be representing the harasser. But it is important to point out to the victim or the harasser, if you're acting for a union, that that's who you're acting for. You're retained by the union to represent the victim or the harasser. Now that has definite practical consequences. It means to say that your instructing agent is the union. It means to say that you have to make that clear to the victim or the harasser, and that you have to make it clear that you are going to be reporting to the union on the discussions that you have. Now, if the individual who approaches you is not content with that, that can raise problems. There is solicitor-client confidentiality, and if the victim or the harasser objects to that, it may be that the union will not be in a position to represent them. So that point has to be clarified right at the start, that you basically have to make sure that you have the consent of the victim or the harasser to report what you hear and to receive instructions from the union.
Roy, what do you think will be the primary role of an employer who finds its employer's counsel, more specifically, but since we are in those cases acting on behalf of the employer, who's approached with respect to sexual harassment problem or other harassment problem in the workplace?
Well, the employer often finds itself in the same predicament as the union in effect representing both the alleged harasser and the victim of the harassment, and often the harasser is a managerial employee. And I don't want to repeat anything that Barbara said. Obviously, the first thing to do is a very complete investigation, and bear in mind in doing that investigation that there's certain phenomena that exist in harassment cases that don't exist in other types of cases, particularly sexual harassment. First of all, there are usually no witnesses. Sometimes there are in the poisoned workplace variety of sexual harassment, but more often than not, there are no witnesses, which makes the investigation somewhat more difficult. Secondly, it's not unusual for there to have been a long period of time where the victim withstood the alleged harassment without complaint. And those are both factors which would normally work against the complainant in other types of cases. But since they're commonplace in cases of this nature, they should not work against the complainant, but that makes the investigation more difficult. If there's a union involved in where the harasser or the victim is a member of a union, the union should obviously be involved. If there's no union involved, or if one of the individuals is not a member of a union, I think it's important to encourage that individual to seek independent counsel. I can just give you a very brief example of a case I had recently. A large company received a sexual harassment complaint from the Human Rights Commission. A clerical employee, female employee, had been dismissed, and she was alleging, among other things, that she had been harassed by a senior manager who happened to be not the person who dismissed her, but was in the same department. Now, if the senior manager had been left to his own devices, he would have denied everything. He would have gone in swinging. He would have fought the thing to the death. He would have lost, and he probably would have lost his job. Instead, what the employer did was authorized him to go and seek independent counsel at the company's expense. He happened to stumble into our office. We explained the realities of the situation to him. The matter was settled. The company paid a relatively small monetary sum. He issued a relatively innocuous apology. The company agreed to do sensitivity training for him and for other employees. That was part of the settlement. The victim was satisfied. The Human Rights Commission was satisfied, and everybody walked away from the situation relatively whole. If the company had left that individual to his own devices, it probably would have turned into a disaster for everybody.
Thank you, Roy. And Barbara, let's talk about the role of union management cooperation in fashioning these very important anti-harassment policies. As you've heard earlier, there are three stages. There's policy, implementation, and monitoring as the very three basic components. We're going to focus here for a minute on the policy development and what role workplace parties have.
Actually, Lynn, if you don't mind, I'm going to broaden it.
Of course.
That I think it is important. It's not just the policy. The unions play an important role in terms of harassment prevention in the workplace. Now, let me state two factors before I explain that role. First of all, understandably, the union has a concern with the duty of fair representation. But that doesn't mean that with any responsible union that they're going to take on any case for any employee who's alleged or found to be a harasser at all. It means they need to be privy to the investigation, a part of the process, so they are confident in terms of knowing where that duty of representation lies and doesn't lie. Second of all, let me tell you that, in my experience, most union representatives, and I had a recent one up farther north than I like to be, are more sophisticated unfortunately, than my clients' management in terms of harassment issues. Some of the earliest and best educational material I remember seeing is on harassment with some of the big unions more than 5 years ago. And I find that unions, they're smart business people. They understand the demographics in Ontario these days. They understand how many women there are in bargaining units and potential bargaining units, and they are certainly going to make sure they protect their interests. And that when I'm training, I find that, first of all, I recommend, and sometimes it's because they're used to not working cooperatively, both parties, that I recommend that the unions be a full participant in the proactive strategies, that I recommend advisors to informally resolve issues. If you're in a company where it's a bargaining unit, the person you probably have more confidence in, because it's who you're used to going to get your problem solved, is your union rep. So let's take advantage of that, and let's have the union reps as advisors, because both parties, if it's between two bargaining unit individuals, are going to be more comfortable with a union rep as the advisor in an informal resolution. And much of these problems are amenable to that sort of resolution. In the formal investigation process, I recommend that the union representatives be part of that process, the establishment of the process, part of the investigation team, probably not have them be the lead in terms of questioning the individuals, but I recommend that there always be two people present anyway. Let the union person be the note taker, so they're fully privy and in a position to assess whether their duty of fair representation is infringed. And I can find that they are very, very useful and very helpful, and you know, it's a new experience sometimes of they and management working together, but this is not a we-them issue. And certainly in terms of the policy, when I'm drafting them, I usually suggest, I put in a clause about not just management's responsibilities, employees' responsibilities, but the union's commitment and responsibility, and suggest to my clients that they sit down with the appropriate union executive and talk to them about that. And usually they're very supportive of reflecting their commitment in those policies.
Thank you, Barbara. One of the most common questions that counsel who work in this area are asked is, what is the dividing line between socially acceptable flirtation, interaction in the workplace, and sexual harassment or other forms of sort of bantering? And this is a question that counsel are constantly asked by their clients, whoever they may be. So I'm going to turn that over again, first to Jeff, to say, what kind of advice do you give when presented with a fact situation where a judgment call has to be made of that kind?
Well, and I'm going to answer that question, but before doing so, I wanted to add to what Barbara had said. The union, in a sense, is in a very difficult position. It acts for both. Often, if the harasser is not a management person, but somebody in the bargaining unit, acts for both. And so it's sometimes in a quandary. Whose case should it choose? Whom should it represent? And by and large, it decides that on the basis of who is going to be disciplined. It's a defender of people's rights and a guarantor of due process. So basically, I agree with Barbara that it's important that the union be involved. It's going to see that justice is done to both parties, and indeed the very quandary it is in provides it with that advantage, with that extra perspective that because it represents both, it's going to try to see that both parties receive a measure of justice. Now, on the question that you've asked me, Lynn, what's the dividing line? This is a very difficult question. For example, let me give you an illustration. A man may come into at the office in the morning and compliment a secretary on the perfume that she's wearing. And she may say on the first day, well, thank you very much. But what if he proceeds to do it every day? What if he proceeds to do it a number of times during the day? What had originally begun as a compliment can become harassment. And we're not talking here about speculative cases. These are actual cases. And boards, tribunals, and courts have grappled with this issue and are gradually coming around to the view that the test for determining whether something is a flirtation or whether it crosses the line is whether it's unwelcome. Whether it's unwelcome not necessarily in the view of the particular person, but in the view of the class of persons to whom the victim belongs. In other words, the woman on the street. And that's what you have to ask yourself, what would the reasonable woman in the Clapham omnibus think?
Well, I'd like to change the question slightly for you, which is, what about this development of zero tolerance? Is that a reasonable standard? Excuse me.
Well, my answer would be more or less the same as Jeff's, except I'd approach it more on a subjective basis. I don't think there's any way to objectively draw the line between what's acceptable and what's not acceptable workplace conduct. It depends to a very large extent. There are certain reasonable objective standards, I suppose, but it depends to a very large extent on the perception of the individual who feels that he or she is the victim of the conduct. And so it's extremely important for the individual who's complimenting somebody on their perfume to be sensitive as to whether or not that is going to in any way offend the person who he or she intends to compliment. And I think the best advice is, when in doubt, don't do it. And that's not zero tolerance, but that's being very careful. Now, when it comes to other types of workplace harassment, we've been focusing primarily on sexual harassment here. And there probably is some margin for tolerance in that regard. Again, the subjective test essentially is to whether or not the words or conduct are unwelcome. But when it comes to other forms of workplace harassment, particularly racial harassment, I would suggest absolutely zero tolerance in that area.
Yeah, thank you. Barbara, I wanted to go on to this whole other question, which tends to get buried because the incidents of direct one-on-one harassment, whether it be racial, disability-based, or sexual, tend to take prominence. But the poison work environment is an important issue, and one which, in fact, can cause a great deal of stress in the workplace. Can you comment on that?
Actually, I think an important comment on the poison environment in terms of understanding the potential liability and the standard you have to pursue and achieve in your workplace is recognizing that the victim of the poison environment is not necessarily the person who any comments are directed to. And I find people sort of have difficulty understanding this. You really have to work towards no gender, racial, any of the protected grounds comments. You can't even say, well, is someone going to be comfortable with the comments, someone else not? Because the law guarantees a quality of environment that treats people with dignity and respect, and meaning not any environment they're going to find offensive for the entire workplace, which means that sexual bantering, sexual jokes, this group is making them, they enjoy them. This group or this employee who's a witness to them 10 feet away finds it offensive. May or may not be a member of that group. I'm a Caucasian female, find it offensive if it's in this group I hear racist remarks. I'm a potential complainant. It's important, I think that's the key thing in the poison environment, to understand that what that means, because I sometimes find in training people, they're trying to say, well, but if this person finds my jokes okay, or if she doesn't mind sexual bantering, then why should it be a problem? And my answer to that, or if in my work area they like the pinups, nobody's complained, I know over in the office they don't like them, because that's not the due diligence legal standard. The due diligence legal obligation is to create and maintain a work environment that everyone is comfortable with. And it's, the cases have clearly said that the person who can be a victim and can file a complaint is not just the person who you show your pinups to, who you make the compliment to, who you sexual banter with. It can be anyone who says, I'm here as a professional or as a worker, and I find being exposed to an environment that focuses on my other roles as a woman or my other roles as a member of a particular religion or as a person with a disability, I find that demeaning. And I think that's probably the most relevant thing to note about poison environment.
We're fast approaching our time for your questions, and I'm just going to ask Jeff to wrap up on this point, and then I would invite questions from the participants.
Yeah, I would say that this is a major problem area. It involves the collision between the desire to prevent sexual harassment and the interest in maintaining such basic things as freedom of speech. If you have, for example, an individual who refers, say, in a classroom, a professor who refers in a classroom to a judge as being limp-wristed, without any intention of targeting anybody, but indeed thinking mistakenly that that term means spineless. What happens if a homosexual person in the class is offended? What do we do in this area which involves the intersection of freedom of speech and a desire to not to be harassed? The example I've given is a real one, and led to the discharge of the professor involved. So these are questions that I put to you as being going to the core of the dilemma of what constitutes sexual harassment in today's society.
Thank you, Jeff. Now, are there any questions from those present? Yes, I'll repeat the question for those who can't hear it. Please. Could everyone hear that question? Is there anyone who couldn't? All right. Can we just start with Barbara here, and we'll just go down the line. Please keep it brief.
Barry's asking that question because of the expanded powers of arbitrators to deal with human rights statutes. Barry, the simple answer is yes, and certainly from my experience a few months ago on a Canadian Bar Association program, on that very issue. My impression is arbitrators, understandably it's more business, are certainly looking forward to dealing with the flood of human rights issues that are arising in unionized workplaces that will be appropriate to grieve. Roy?
The trend really has been mandated by Bill 40 and otherwise by the initiatives taken by unions in trying to negotiate sexual harassment and workplace harassment clauses into collective agreements, and the trend has certainly developed there. So I think that's the reason for the trend, is because the collective agreements tend to deal with the issues now. I see that as a positive thing. The downside to it, of course, is it just gives rise to another aspect of the multiplicity of proceedings that can arise in these situations.
Indeed. And Jeff?
Well, I think that the first thing you have to do is consider your options, and your options may be to go for an internal remedy and try to mediate the thing with the employer on a without prejudice basis, or grieve under a collective agreement to arbitration, or go to the Human Rights Commission, or even take a legal action in the courts. And it is true that since the amendments to the Labor Relations Act, arbitrators now have the power to apply human rights legislation. And if you are the alleged harasser and you've been disciplined, you're more likely to go there. But if you're the victim, there are remedies that the arbitrator can't administer. The arbitrator can't, for example, order that the harasser be relocated. And there are various remedies, and he can't give systemic remedies against the employer very easily. So there are good reasons for going to the Human Rights Commission. The problem is it takes forever and a day. And I do predict myself that more and more arbitrators, if they're smart about it and deal with these things intelligently and receptively, will get more of the business.
Thank you. There's a question over here. And if I didn't quite get your question, but if you're wondering whether or not that's a trend, I will take 1/2 minute myself to say I'm resisting here as the chair. But of course, we will be able to comment, both Barbara and I will be able to comment on just how common that has become. For cost reasons, for time reasons, to make sure that the workplace continues to be the center of dispute resolution, those kinds of policies are absolutely standard. But the one thing that I say is also standard in them is to make employees aware that they have other options. They must be told that they have options other than that internal mechanism. And I would draw to your attention Ontario Human Rights Guidelines on the conduct of internal human rights investigations, if you're unaware of it. But with that, I'll turn it over to the panel.
I think
If
this
I-
is...
sorry.
Go ahead.
Just
no,
going to go
ahead,
down the
Barbara.
line.
If I read you correctly, I think you're distinguishing even a formal internal complaints procedure, where you have a written complaint and investigation, from informal internal processes. I don't know if it's a trend yet. I hope it'll become so. I'm finding people, I promote that and finding organizations very receptive to it. And the reason, not just cost and expediency, the bulk of human rights issues, and I've probably been confronted with hundreds and hundreds over the years, the bulk of them are the type of issue that can be resolved and in terms of the resolution meets the interest of both parties too, informally. There can be the severe issues, the pervasive issues. The bulk of them are the unfortunate comments, conduct, that quite frankly, in the gender sense, we spent the first 30 years of our lives, if we didn't work with the other opposite gender, learning to react on gender differences. And now we have to learn a new skill. It's not because we have some severe, peculiarity in terms of the way, I always say everyone in this room, including myself, were probably potential sexual harassers, given the definition of it, and given that we all have learned how to interact on gender, and we're capable of doing that in the workplace. So given that the bulk of the solution is educating and equipping people with a new way of dealing with each other in the workplace, informal resolutions, which is a team of sort of trained advisors, supporters, who can help bolster you with self-help or intervene between you and the person who made the comment to deal with the issue. I hope it does become a trend because it meets the employer's need, it meets the victim's need, and it meets the harasser's need in terms of more effective resolution.
Thank you. Yes, I hope I've got the right order. Right ahead.
Sure, it's binding. What it isn't binding on is the commission. And I made that comment. It's not binding on the commission. In fact, you want to know something? It was the commission officers who were as frustrated as I was with this stupid gag business that said, Barbara, why don't you do this? You know, and we'll never hear from you again. And I said, great idea. And they're as frustrated as we are in terms of this gag business because, you know, there are a lot of things that could be and should be settled, but because of that nonsense. If they want to educate, spend the money educating, but you don't do it by blasting people in the press. So you are taking a risk, but I guess my practical response was the commission has enough business without them going looking for more business. If a complainant is fully satisfied, I can't say it's risk-free, but it's very unlikely the commission's going to pursue it.
Just want to make one comment. In a case that I'm involved with right now, the officer suggested the following as we were approaching a settlement. In view of the fact that there is counsel who is aware of human rights obligations, we as the commission will assume that the counsel has advised its client as to its obligations. This is in addition to all the other mandatory terms of the settlement. So they took into account the importance of having had counsel there who were familiar with the obligations and used it as a justification for the commission accepting the settlement. So I think that showing that you are aware and are willing to convey those obligations to your clients, whether they be unions or employers, is terribly important. I'm sorry we're almost out of time, but I am going to take one more question, which I believe is this one here. Can you two flip between yourselves? Thank you. All right. Yes.
In terms of the counsel as investigator, can you also comment on the role and the appropriateness of having a private investigator?
Okay. Is there a role for private investigator? Just so I can rephrase that question, there are both, everyone in a sense is a private investigator who's outside of the commission. So I believe, Roy, did you wish to comment on that?
I don't know whether the question employs a private investigator in the sense of a gumshoe or somebody like that, but there are some cases where it's appropriate to have an external investigator. I know the Ontario government has developed a policy now whereby the investigator in workplace harassment complaints isn't external to the government, but is external to the department or the ministry in which the complaint arises. From time to time, those of us on the employer's side have all been asked from time to time to act as investigators because the client thinks that because of the nature of the case, we bring a set of skills to the party that others may not have. So I think there's certainly a role for external investigators, and counsel can adopt that role quite often.
Well, thank you very much, and we're going to move on now to the next presentation, and we will try to pick up questions that relate to any of these issues later on if there's the time, and I hope there will be. Our next speaker is Barb Butler, who is going to speak on the topic of drugs and alcohol, employee testing, employee assistance programs, and absentee control. As you will see, Barbara has an extensive paper in the materials, and the same format will follow, that there'll be a panel discussion with the opportunity for questions at the end. Barbara, can I move you? You certainly can. Let me move this then.
Hi.
started. I'd like to thank the organizers first for changing the agenda because I have to fly off to Edmonton and the choice of flights was limited. As the other Barbara found, 20 minutes is an obscenely short time to talk about such a complex topic as this. One of the reasons I know it's so complex is because I'm working with companies from coast to coast, developing policies, implementation procedures, communications. I'm advising both the federal and the provincial governments, and I'm working on a lot of the legal cases associated with this issue. In fact, some of the lawyers in the room have worked on those as well. I've had to deal with every aspect of this topic, and including the very key priority of involving labor and other employees in the policy development process. So given all of this and the time limitations, I'm only going to be able to hit the highlights for you. And what I'd suggest is read the handout, read my book. There's information out on the desk about it, and call me if you have questions. I'm more than happy to help out. So what we're going to do is look briefly at the problem in Canadian workplaces, what companies are doing about it and why, and give you some basic information about policy development and some employer mistakes if we've got some time. These are in Helvetica 24, so hopefully they're legible. Let's just start with the concept of what's going on in Canada right now with this with drug and alcohol use. It's not an epidemic. It used to be on the decline, and now we're finding with the most recent surveys, particularly amongst student populations, that it is turning around. So I can't guarantee that it's on the decline, and we're still concerned that it's at absolute levels that lead to negative impacts to society and a high financial cost. Now, unlike the Americans, we have a different problem here, which is why our solutions need to be different as well. We have a higher population of current drinkers. We have a lower level of current drug use. To give you an idea of what's happening in the labor force, and don't worry about the numbers other than to say that this is from the Health Canada Alcohol and Other Drugs Survey from 1989, and as you can see, 85% of the Canadian labor force consider themselves current drinkers. That's past year, and 10% of those are heavy drinkers, and that's where the problem may come into the workplace, and as well 8% have used other drugs in the past 12 months. Now, this information, being 1989, is somewhat out of date, but Health Canada is repeating the survey. They're pilot testing it right now, and they will be in the field in September. So we should be able to get a better idea of trends and current patterns, and we've asked them very strongly to split out labor force data so we know what's going on in the workplace. In addition to the Health Canada work, we've had quite a number of studies in Canada that look at the labor force specifically and ask employees themselves the nature and extent of consumption patterns, the impacts in the workplace, and their feelings or views about policy issues, including the controversial issue of drug testing. Now, I'm not going to go through all of these surveys. They're referenced in the paper, and you can find out more about them. I think the key is that most Canadian policy development is based on some very solid data. What we found with the United States policy development is they decided they'd start with a war on drugs, and then from time to time they'll do surveys to see what people think about drug testing. So we have a far better base of data to work from. And what we've learned from these Canadian surveys is that the substance use levels are essentially no different than general society, but they are causing accidents and other negative impacts, and the most frequently reported contributor is alcohol. Which matches our pattern of use. When asked, a low percentage of workers believe their own substance use has caused an accident or another incident, but when asked about their immediate work group, they are reporting that it does contribute to a number of negative effects, including accidents. And in all of the surveys, a high percentage of employees rated substance use as an important contributing factor to safety risk. And this is what's important. Now, just for those of you that haven't worked on the medical side of this, alcohol and drug use can affect performance when it is associated not just with current use, but also with hangover effects and with withdrawal. And it can affect quite a number of motor skills. And the effect that they have on these variety of skills, and this isn't just hand-eye, it's also decision-making, concentration, planning, etc. The impact that it can have is to reduce productivity, reduce efficiency, and reduce ability to operate safely.
So what we've learned from the scientific studies, from field studies, and from employees themselves in the surveys is that alcohol and drugs are affecting quite a variety, are having quite a variety of impacts in the workplace. The difficulty we have in this area is we do not have a lot of Canadian studies, and we're trying to extend the work of the Canadian Centre on Substance Abuse, the Addiction Research Foundation, and Health Canada to get some basic Canadian data in this area. We do have one survey that was done in 1992 by Gallup Corporation, and it looked at quite a variety of questions of 1,000 employed individuals scattered across the country. And what we did find was when the employees were asked about their specific workplace, over 50% said that alcohol or drug abuse was affecting employee attendance, morale and motivation, company productivity. Nearly 50% said they felt it was affecting their own company's healthcare costs, 44% safety in the workplace, and 32% crime on the job. So these are employees themselves talking about their immediate workplace and the concerns they have, and this was a Canadian study. So the reaction to this is that increasingly companies in Canada are making decisions around policy development. There's some pressure coming on them from pending regulations. Some of you may have heard that Transport Canada had draft regulations with the last government that would have affected not only the transportation sector, but any company in Canada that had a transportation arm, be it trucking fleet, air service, whatever. Those are on the new minister's desk. We don't know what direction he's going to take, but it certainly got the attention of a lot of companies to begin looking at this issue. In addition, we're affected potentially by American regulations. Those regulations have been postponed in application to foreigners until January 1996, and will directly affect all truck and bus drivers that cross the border, as well as all flight crew that are flying in U.S. airspace. And the U.S. industry has made it very clear that they expect a level playing field when drivers and flight crew are in the United States. So it's unlikely that they will back off. I guess the issue is whether there can be any discussion of modifications to the requirements. The requirements are very stringent and are focused primarily on random drug and alcohol testing, with a number of other testing components surrounding that. So we're also, a lot of companies are concerned about drug use and performance, given the information that I went over with you, but as well they're interested and are concerned about the liabilities associated. And these can be legal issues such as occupational health and safety, due diligence, reasonable accommodation and how far that extends, the need to identify intent to search, and oh yes, social host liabilities, where alcohol is being used either in company functions or as a part of doing business, and the liabilities around hosting somebody who becomes impaired. So there's increasing number of reasons that companies are looking at this, as well with the great move towards developing policies in the United States. 88% of firms now in the United States who responded to the American Management Association survey on this issue have some form of drug testing, either for applicants or current employees. So it's become almost a religion down there in all sectors, and a lot of companies are asking their Canadian subsidiaries to develop policies. For the most part, they're not directing what should be in those policies, but they are expecting something done. In addition, a lot of Canadian companies are recognizing their due diligence liabilities around those they contract to, and are requiring contractors to have the same regard for safety and some kind of attention to alcohol and drug issues. When others in the industry start taking a lead on this, many companies will follow suit and at least begin to address the issue. And many companies that have employee assistance programs are now deciding that they should be being clearer in terms of their stand on drugs and alcohol. So with all of these issues, there's a number of trends in program development. Relatively few Canadian employers have testing programs. More appear to have employee assistance programs, but we don't have really a good gauge on that. There haven't been that many studies done recently. But the programs that are in place tend to be comprehensive and are usually in place where there's a safety risk or concern: transportation, oil industry, construction, manufacturing. So increasingly more and more companies are paying attention to the issue. success in developing a policy comes when policy is well planned in full consultation with employees. The best successes that I have had with policy development is when we've got people around the table, union representatives, employee representatives, managers, stakeholders, so that we can make sure that we've developed something that can have commitment at all levels and understanding at all levels. There also needs to be adequate resources for development and implementation. A lot of times people decide, let's have a policy, but then they don't realize that these things are not cheap to implement. Bottom line is there's no typical policy because every company is going to be different in terms of their culture, their values, the business they're in, the regulatory environment they face, and their specific needs. A short period of time to cover this issue. Anyway, the Canadian approach to developing these policies is one that has 4 tiers. Awareness and education programs are fundamental. Access to assistance, employee assistance programs or some other community service is essential. Supervisor training for their role in implementing the policy, and problem identification, methods to identify the problem. Now, and this is where the concept of drug testing comes in, but it's absolutely and certainly not the only method of problem identification. Peer prevention, performance management systems, voluntary referral as a result of the education awareness program can all be fundamental components of problem identification. So rather than going to the policy development process, which is in the paper, and rather than going into the key policy components, which are fundamentally those 4 areas, I'll just reference that when we're working on these issues, some of the most difficult policy decisions and the ones that really do have legal ramifications are the ones that are around the use of alcohol in conjunction with company business, social hosting, in many companies it's a norm, but now people are realizing the liabilities when they host someone past the point of intoxication and they drive off and may crash and injure themselves or others. So we're placing a priority on addressing that in policies. Provisions for contractors associated with the extension of due diligence for what the contractor's responsibilities are. The issue of whether certain jobs will be identified as safety sensitive and whether those jobs will have specific policy components, tougher standards, recognizing the due diligence. And where do you draw the line? What is considered risk? Each company is different. Dealing with impaired driving charges is becoming more important because we're recognizing that repeat impaired driving offenders, it is a signal that there may be a problem. And for those companies that have people that drive in the course of work, how far should they be looking at this issue and doing something about it? Disciplinary procedures is always extremely tough. You get the whole policy written, and then you go back and you say, okay, what are the consequences for violation? And that's where a lot of groups have a difficult time. There also, the issue of whether to include alcohol in drug testing is extremely controversial and takes a lot of discussion. And then whether and how to conduct searches, who's responsible, how they'll be done. So those are and all of those policy decisions, as I said, do have legal ramifications. I'll leave you with two thoughts on alcohol and drug testing, because this could take 2 days of discussion. First of all, if a company is looking at whether to test, if a company is looking at whether to test, they've got some very critical decisions to assess. They want to look at who they're going to test, who falls into the category, who doesn't, or is it everybody, under what circumstances they're going to test, and there's about 10 different situations one might build a testing program into a policy, what substances they're going to test for, what methodology they're going to use, again there's lots of options, and what the consequences are of a positive test. The other piece of this is addressing the myths and facts, because believe me, there are a lot of myths out there. So one of the issues is drug testing legal? We don't know. We have not had sufficient legal precedents here, although there are some arbitration trends that are beginning to give us a feeling for where it's going, but it's too early on in the case history to be able to say definitively one way or another. Is alcohol and drug testing acceptable? We don't know. We don't have any surveys of individuals who are currently subject to testing programs to find out what they think about it. Certainly the earlier surveys, Imperial Oil, Transport Canada, employees said fine if there's a risk to the job. There was quite a surprisingly high level of acceptance. But that was before people were subject to testing programs. It would be interesting to know how they feel now. Is drug and alcohol testing effective? We don't know. It's very hard to isolate testing programs from the more comprehensive body of a policy to be able to determine definitively yes or no, is it effective. There's certain feelings around random testing programs on the roadside that they've been effective, but again, they're tied to education and awareness. So this in isolation, we don't know. Is alcohol and drug testing accurate? Yes. It is accurate as long as proper standards are followed, as long as the proper procedures are followed, and as long as the testing lab, no problem, as long as the testing lab is certified by the Canadian Standards Council of Canada, and as I say, the proper process is followed, and that is extremely detailed, and if anyone wants to talk about that part of it, we can do it at another point. So I'm going to skip the common employer mistakes, and I'm just going to leave you with one priority that I like to place on all policy development and all decisions in this area. It's the need for balance. The balance between health and safety, due diligence concerns, legitimate due diligence concerns, and individual privacy. The balance between the needs of all stakeholders in a business organization. There's a balance between employee interests, union interests, management interests, client interests, community interests. And there's also a balance between measures to control or deter alcohol and drug use and the commitment-based approaches, which we've discussed. And that's why the slide I showed you with the 4 corners attempts to show that balance: education, training, access to assistance, and methods of identification. So there's, needless to say, lots more to say, but we won't do it because I've been cut off. So if you have questions later, I'm happy to answer them.
I'm going to chair this panel, and I've asked Barb Butler to join the panel. But before I do, I'm going to exercise a hitherto unknown prerogative of the chair to add a few words of my own. Barb has put the case, I thought, pretty well for a more or less balanced approach to this matter, but she very fairly ended up by saying, on most of the vital issues involved in this matter, we don't know. We don't know whether it's legal, we don't know whether it's acceptable, we don't know whether it works. And she said, but we do know it's accurate. But even on that latter issue, accurate as to what? What does drug testing really test? It doesn't test, for example, whether there's any drugs in your system necessarily at the moment, but whether there was at one point in time within the last 30 to 60 days, and not how much, and not in what circumstances it was used. And so, but we do know. We do know that such testing can disclose other things that you may not want, that an individual may not want his employer to know, such as whether he's a diabetic or has AIDS or whatever else. And it's these matters that give rise to concern on the part of unions, for example, about the privacy considerations. And it's these things that have led such bodies as the Ontario Law Reform Commission, the Canadian Bar Association, the Ontario Privacy Commissioner, and various arbitrators to say it's simply not acceptable. And so in this regard, I would urge that you, if any of you have any time, that you read a decision which came out last month by an arbitrator in British Columbia, Mr. McAlpin, a 70-page decision involving Imperial Oil and I think the union out there, whatever it was, the chemical workers or the paper workers union. He explores all these issues very extensively. But privacy advocates have other concerns. They believe that drug testing will lead to genetic testing and to continuous monitoring of employees. And they also say, I mean, if you clamp down on one form of drug use, which is illicit, you simply give rise to an increased use of illicit drugs, such as tranquilizers. And if you're going to test for drug use as being the cause of accidents, then what about all the other things that cause them, fatigue and stress and illnesses? And what you end up with is, of course, a totally exposed individual who's constantly being monitored, surveyed, pried, poked, and humiliated. So there is a real problem in this area as to where we're going. We don't need to defer to the hysteria that has run rampant in the United States, and I don't think we're going to. The only areas where this has been utilized so far extensively, I believe, is in the prison system and the Canadian Armed Forces. And whether companies are going to be able to do it is a matter for determination, as it was in BC. And in BC, the arbitrator said, look, you've got management rights and the concern for safety on the one side, you've got consent on the other, but let's balance the issues and let's decide where we're going to do it. And that's my first question to the panel. If we get into balancing the interests of the employer and the concerns of the employee, where do you end up? Where does the balance, where does the line fall? And maybe I can start with you, Lynn, on this question.
I'm going to answer that in a slightly different question because of our audience today. I think what is extremely important for you to know as lawyers are your client's legal obligations. As some of you may be aware, there are limitations on drug testing and even in drug response in the workplace today. But as Barb Butler has quite properly said, they're not well defined. But the biggest trap for organizations today is the issue of when a drug dependency becomes a disability. Because when it crosses over the line, when it's no longer simply a question of drug abuse, then you have human rights considerations. Because as soon as it can be alleged, let alone established, and there are many cases on this, that the drug, whether it's alcohol, legal or illegal drugs, has become beyond the level of simple casual abuse and has become a dependency, then it qualifies as a disability. Once you're into a disability, as you will hear later, you're into issues of accommodation, including issues of accommodating extended and frequent absences that can arise due to illness or injury. What I think is the important line to draw is the line where it's not as far gone as a dependency. For most employers, the issue is short of dependency. But before the response is taken, that issue must be addressed. The second case that I'd just like to draw your attention to a case as well, which you may be aware of. It's a 1992 Federal Court of Appeal case called Niles. And in that case, the employee was absent for 29 workdays out of 140 possible workdays for alcohol abuse. And eventually, after CN tried to work with the employee was terminated. He was subsequently reinstated, and that was upheld. And the discussion, that's why it's an important line for you to understand, is when it crosses over into disability. And finally, I think it's also important to know about privacy legislation. Privacy legislation is really an issue for public sector employers at present, except in the province of Quebec, so that privacy legislation does not extend its protection to private sector employees at present. But that doesn't negate the importance of recognizing what we'll call at this moment moralistic employee concerns. So the kind of balance that I'm speaking of is the balance between recognizing the right, if there's such a thing, of an employer to have a drug-free workplace. I don't think that's the test. The test is something other than having a drug-free workplace. It's, if you use it in terms of human rights, it's can the employee, even with drug problems, perform the essential duties of the job? And if there are is it a bona fide occupational requirement to be completely drug-free for all positions? And what accommodation is required? And in other words, what you're hearing is a movement from sanctions or threats or penalties for these kinds of problems to assistance and monitoring and trying to work with the employee who has this difficulty.
Well, that's, Chris, did you have a view on that issue?
Jeffrey, I've got some things I want to say, but not directly on that issue. Is it
well, certainly, you can, now's the time.
I think what's important in this whole process is to distinguish between what is misconduct and what is disability. And in any procedure, one would have to determine when is alcohol or substance abuse an act of misconduct and when is it the result of a disability on the part of the employee. And I think a useful way of looking at that, and I'm going to have only one overhead. This overhead, incidentally, is in your files. If you go on a bit, about halfway through, you'll see it says a theory for alcohol problems in the workplace, if you want to look at that. I'm going to put it up. Can you see that? It starts with abstinence. In a sense, we all start at some stage as being abstinent. to occasional drinkers, social drinkers. Now, these categories are defined on the next page as to what I mean by how much alcohol this is per day or per week. These are categories taken from the British Medical Association. Moderate drinker, heavy drinker, problem or trouble drinker, and then there's a question mark here which I want to discuss briefly, and then a triangle. And I think if one looks at most cases that come up in arbitration, what you're looking at are cases of people within the triangle. And rather different from what Jeffrey was suggesting earlier, I think the problem with most procedures is that by relying purely on the EAP type tests, which are people's behavioral responses, if you turn over the page in your file here, it says identification of alcohol problems, intoxication. It says work-related criteria. Those kinds of manifestations will appear with a late onset of serious alcohol abuse, actual dependency, which is on-the-job absenteeism, sickness absence, AWOL, subjective clinical signs, person coming to work drunk, that sort of thing, progressive deteriorating work performance, employee relations, poor relations with fellow workers and superiors, supervisors, accidents. And in a sense, what you're dealing with here, the point of the question mark here is that if a person passes into the dependency triangle, that person can no longer have an unproblematic relationship with alcohol, which means that in studies of dependent drinkers, they've found that the accumulation of dependent drinkers is either in a state of dependency or in a state of abstinence, but very few are able to maintain social drinking patterns thereafter. What that means is that they tend to move around this triangle, start as dependent drinkers through a program of treatment, either successful, in the long term remain as abstinent. Some will think that they can make it as social drinkers, they'll go up there for a while and may succeed. Some few will succeed and many will return to a stage of dependent drinking. Now, the focus of most cases, most employer programs is upon this kind of worker because of the fact of the inability to detect patterns here, heavy drinking, problem or trouble drinking, where somebody still has the capacity of returning to what I would think is a socially desirable state, which is social drinking and moderate drinking. That ideally one wants one's working population or within that area, rather than in problem or trouble drinking, you're starting to get problems of people spending too much money, problems at home and so forth on drink. Now also your heavy drinking and problem drinking grouping tends to be people in the age group age 18 to about 35. That your dependent drinker tends to be people with a stabilized drinking pattern older than that. And to my mind, there is substantial value in regulated forms of testing, medical testing, which can reveal these patterns. I mean, I respect everything that Jeffrey's saying about the need to regulate that properly as to who retains custody of the information and so on, but there are tests. I mentioned over here, it says measurable objective identification tests, leaving aside number 1, which is the direct testing of breathalyzers and so on. The indirect objective testing, these biochemical tests, the gamma GT and the MCV test are 2 tests that can be taken which show a pattern of drinking. There's nothing like this equivalent in drugs to show problematic drug taking. But the MCV test shows in older drinkers, in older people, when their livers are not as efficient as very young, the MCV shows an increase in the size of the red blood corpuscle. And that shows a pattern of drinking over a period. And you can see improvements there very, very rapidly. So that, for example, while I'm not in favor of last offer opportunities to a worker's in the triangle and has just been dismissed and discharged and is given a last offer agreement either by the arbitrator or by the union and management representatives. The problem with that is that there is always a relapse afterwards. Even if somebody's cooperating, they will relapse 2 or 3 or 4 times. If they're given a last chance, they're going to fail that last chance. But if they are rather given, for example, these gamma GT or MCV tests, periodic tests every 3 months, the medical department should monitor it, not the management. The medical department should be able to say, this person is cooperating, because you will see a decline in the MCV or gamma G rates.
Thanks, Chris. And,
Sorry.
thanks. No, that's Barb. Perhaps you could join in on this point and indicate if there are any differences between you and Chris on this, or whether you are basically going in the same direction.
We're totally in the same direction in terms of the circle of dependency and the issues. One thing I wanted to add to what Lynn had to say in terms of the various legal issues one has to deal with is one of the best ways to begin is to have a clear policy. Rather than responding to disability issues or impairment in the workplace or attempting to do a random search without any warning, I think it's very important to have a clear policy. And then it won't guarantee that you won't be challenged, but it will guarantee that employees understand what the rules are, but also where the balance is in terms of the services and the assistance that companies will provide them if they do have a problem and want to get assistance. The only other thing I want to we didn't go into testing in great detail, but I want to reiterate the accuracy issue. The process is accurate. The question is, what questions are you expecting it to answer? The physical process of collection, analysis, medical review, and reporting can be accurate provided you take the right precautions and use the certified labs. But you've got to get back and decide what questions do you want the testing to answer. It's limited in what it can answer, and that's where the difference comes. And with respect to the IOCO arbitration, it is out. You should get a copy of it. It's very interesting. It's also under appeal by the company.
Lynn, I'd like to come back to you on this because some very interesting things have been said. First of all, you've indicated that alcoholism or drug dependence may constitute a disability under human rights legislation, and the problems that has in whether the accommodation that an employer consequently has to provide for an employee, and also the time at which the accommodation can stop and the employer can legitimately say that the employee has to do a day's work and can terminate the employee's employment. That's a very difficult question, I take it, to answer. And then there's Chris's observation that the whole basis upon which all of our arbitrators are proceeding right now is fundamentally wrong, that there's no point in giving employees a second chance because they need a third and a fourth chance. And we should, instead of approaching it at the back end, we should approach it at the front end by very early testing. I'm not sure where Chris would start to test, just perhaps after the end of the initial abstinence period. But Lynn, what do you make of this comment, this observation that Chris has made, that basically arbitrators are barking up the wrong tree, and that we should basically get in the proper approach is much earlier detection and identification of the problem?
Well, I'm going to address the testing issue, certainly. And again, I would certainly draw to your attention the existence of a policy of the Ontario Human Rights Commission on drugs and alcohol testing. And the reason I draw that to your attention first is that there has been a very limited view, even by the Commission, on what is the appropriate approach to this. The Commission's guideline, in a nutshell, looks at the issue of whether drug testing is a form of employment-related medical examination. And they've made it clear on other occasions that such inquiries are completely prohibited until, that's their statement, until there has been a conditional offer of employment made. In other words, the medical examination must be outside the scope of the offer to employment. Once that's made, then it can be a condition of employment that there be success on a drug test. But you've already heard, all of you, and when you have the opportunity to read Barb's very comprehensive paper, you'll see that that is a one-shot deal that will address that question at that time. So it doesn't really address the issue of longer term or more frequent testing, and under what circumstances those tests should be conducted. From a legal point of view, it is a murky area. But it seems that the test at present is called reasonableness. And that's an old term to lawyers. But reasonableness in these terms include, what is the nature of the job? Is it safety sensitive? What is the nature of the duty involved? It's been suggested that it might even extend to persons who have financial responsibility or decision-making powers on a regular basis because they have the ability to impact the organization. What is the purpose of the testing is the very tough one for most organizations. What information are you trying to get? There's a positive test. What do you do with it? And in the past, the instinct of many organizations, many employers, has been to fire the person or to demote them or in some way control them. As I mentioned earlier, and I won't repeat it, the trend is completely the opposite now. It's assistance, monitoring, trying to work with the person. But still, the very tough line, and I'll leave it at this because it's a much bigger question, is that there are limitations on testing. And I suppose it again raises the issue of, even if you get a positive answer, what are you going to do with it? It does not help you answer as counsel whether the employee has passed over the line from being a casual drug abuser into a dependent user of drugs or alcohol who would then qualify as a disabled employee. So what this calls out to me is for investigation and working with the person on a much more constant basis and not let it get to a crisis point that results in it going to the grievance or to any other step such as the Ontario Human Rights Commission.
Before opening up the floor for discussion and questions, I just have one other issue that I want to ask the panel about. It would seem that up to now we've been operating with EAPs and performance evaluation and rules and various kinds of supervision to deal with these problems. We're now on the threshold of a move into basically a more invasive monitoring and testing, and the question is whether we go that route and how far we go and how early we go in it. One other approach that I see employers more and more resorting to is tightening up their attendance control programs. Presumably, alcohol and drug addiction reflects itself in attendance problems, and there are a number of cases now in the arbitration awards in which discharge follows upon a certain number of absences, even if it's for innocent absenteeism. 4 absences, within a given period, and you're gone. And where medical certificates are required automatically, regardless of whether there's any culpability or any misconduct or whether the absenteeism is innocent. And these have received received a poor reception from arbitrators who regard it as a violation of collective agreement rules and also of human rights procedures. Do you have any comments to make upon the efficacy of attendance control programs? Chris, I'll start with you, and then Barb, and then Lynn, and then we'll go to the floor.
Jeffrey, I wanted firstly to say something on the testing. I personally think that any invasive testing, medical testing, should be the property, or the information derived from that is the property of the individual worker and the medical department. Not here, but in South Africa, there have been agreements concluded between unions and management on this topic, substance control. And the agreements have been along the lines that the medical officer is jointly appointed by union and management, and the counsellors are jointly appointed with a limited tenure, so that if there's any breach or any dissatisfaction by the workers in the way that the medical department is handling the information, they've got an ultimate sanction in being able to replace the medical officer. The effect of that is that the medical department is only able to report by agreement between the parties whether there's cooperation or there's not cooperation from the worker involved, from the individual employee. As regards the other testing, which is testing for misconduct that's being under intoxicated at work, they're very different kinds of breathalyzers, which if a union is not involved in the process of regulating those, there's some which are highly unreliable and some which are much more reliable but need proper calibration, and there are procedures, for example, in some of those agreements where the parties will jointly calibrate these instruments.
So, Chris, you see a role for the union in getting involved in these matters?
Absolutely.
And Lynn?
Well, I was going to defer to Barb, who's had limited opportunity to say anything before the... What I think is important is what Barb has noted, exactly the point that Chris has just said, which is it's terribly important who actually does your testing, how it is conducted, who it collects the samples, who actually tests it, are important technical points. But again, to me, this doesn't really address the root question, which is what are you trying to do with drug testing? And I believe that there has been a knee-jerk response among many organizations, which in part is driven by the war on drugs mentality that's come from the United States. And you've seen examples here today of just how untrue the factual basis is for a war on drugs. It just doesn't exist. But that doesn't ever alleviate employers' concerns, safety concerns, health cost concerns, so that we are not going to see this issue go away. And I just want to leave it before we go to the floor from what I have to say, that the most important thing is to develop a policy, because in developing a policy, it forces the organization, first of all, to work with the stakeholders and to determine what it is trying to achieve with this policy. By writing it down, it actually commits the organization to saying what it is trying to achieve with the drug testing policy.
Barb, you're the last speaker.
Okay, just really brief. On the last words that Lynn spoke, I hope everyone in this room will realize that the American approach has been one of developing a drug testing policy with a few doodads attached to it. The Canadian approach is to develop an alcohol and drug use policy, and it may or may not have drug testing as a part of it. So when companies come to me and say, we want to develop a drug testing policy, I say, well, I'm not your person. If you want to develop a comprehensive policy that looks at the pros and cons of whether testing will meet your requirements, we can talk. And so it's very important on all of those issues that I put up that are critical and very difficult decisions, that you walk through the basic objectives of the policy, establish where you want to go, and then look at the pros and cons in terms of whether you need them or not, and to what end, what purpose they will serve. And then by that means you'll come up with a policy that makes sense for the organization, one that it can both communicate and defend if challenged.
Thank you, Barb. And now, can we have questions from the floor? I'll start on this end. 1, 2, and then 3. Yes.
Not with the companies I work with. However, it's certainly, there's that potential, because a lot of companies haven't paid sufficient attention to their performance management, to training supervisors, and to focusing on in that area, and it may be seen as an easy way of addressing a problem, but it won't. It will not resolve that problem. I have heard tell of some companies going that route, but for the most part, there really is a focus on the prevention, education, access to assistance route in Canada. But certainly if you look at the statistics from the American Management Association in the States, the testing drives the policies, and then some companies have prevention programs going with it. We're attempting to take a significantly different approach here.
Yes.
Sure. I think Barb's paper is excellent on that point, in the sense that she argues in favor of a comprehensive program. And unless you have employee involvement, employee consent to the process, it will just come across as repressive and will suppress the incidence of it. I mean, it will encourage subcultures of illicit drinking, which is not the objective of the process.
Yes.
We have Johnny
Well, that's a long question for a short answer, which is all I can give. There are cases that address facts that aren't so dissimilar, believe it or not. They're not quite so obvious. And generally they are in the transportation realm, which gives the hook that allows the employer to respond because of the safety-sensitive nature of the job in question. But to answer your question more generically, I believe that what that kind of evidence is, let's take the alcohol. You believe the person from an anecdotal response. As you pointed out, you're not a Marcus Welby, but from an anecdotal response, it appears the person is inebriated. And they're on the workplace. Well, see, I would not be prepared to go that far, because that's the difference between death and murder. That is, in both cases, the person is dead, but in one case, it's a legal conclusion. In your instance, to conclude that it's an alcoholic, that clearly pushes the employer into the realm of having to deal with it as a disability. Because once the employer has made that determination that there's a dependency that amounts to a disability, which is what I would suggest that example says, I believe you have to deal with it as a disability. And then you're into those realms which I've already discussed and I won't repeat. Essential duties of the job. Can the person...
What about the employee denies that disability? What do you as an employer do?
You offer, you counsel, you offer the existence of programs, and you continue to make it clear that they must perform the essential duties of the job, and you will accommodate them. And if...
No, I don't have a disability. I'm not following EAP. I'm not going to your supervisor.
That, if I could ask you, just because of our time constraints, and I'm sorry to direct you, please read the Niles case, because that's a really good example of the facts are not so dissimilar from that. I believe I have the citation with me. I'd be happy to give it to you at the break.
Barb, would you like to add something on that?
Just one minor thing. Don't train supervisors to diagnose. They should not be diagnosing. Their focus should be on performance management and fitness for duty, and the policy should allow, if there's some concern about risk to self or others because of the ability that someone may have to do their job at that particular point in time, the policy should have some clear guidelines on escort from company property and on fitness for duty assessments, where an occupational health physician can assess the individual and then go from there in terms of what, but you've got to separate performance from and fitness for duty issues from dependency issues, and focus on that route, because that's where the supervisor and the company's primary focus should be.
I would add to that only that let's say you do fire the employee, and you have a paper record of everything you've done to offer help, which has been refused, and the employee then goes into a post-discharge rehab program. The Quebec Court of Appeal has just ruled that evidence is relevant in determining whether the employee can be reinstated. So the employer may still find that employee back on the doorstep. There was a question, yes. That's the key question that I think we started off with and that Lynn addressed. And Lynn, I don't know if you want to say anything more. I actually was trying to put that question before, not as clearly as the questioner just did. But when does the duty to accommodate stop?
Well, fortunately, we just have had the expert on that issue arrive, so we can discuss it later. We have our next panel coming up on accommodation. When does the duty to accommodate stop? As you know, the legal test is to the point of undue hardship. That is the legal test. And that has been colloquially, although I don't think completely accurately, described as to the point of near bankruptcy. I think that is an unfair way to characterize it, but it has been used frequently in the commentaries. In a nutshell, what it means in the fact situation that you've described is that repeated absences or even extended absences where there has been a conclusion made or even an allegation made that there is a disability is ongoing. The accommodation is ongoing, and it takes many forms. It means tolerance of the absence, unless it can be shown, and this is what I want to get back and reiterate. I think Barb and I are echoing each other on different levels here. It's performance assessment. The employer is entitled to ask the employee to determine whether the employee is able to do the essential duties of the job. The employer is also entitled, but this is a more difficult one, to say that it's a bona fide occupational requirement not to consume drugs of any kind to any level. That would be much harder to defend, because it would have to show that the use of alcohol or drugs, other drugs, could result in the inability to do the essential duties of the job. Once it's been determined that the use has transferred over to a dependency and thus becomes a disability, the accommodation is ongoing, extensive, and in many ways requires constant reassessment of what will work. It could be employee assistance programs, it could be monitoring programs, it could be tolerance of these absences, and the like. And I think what this shows is that if employers let an issue get to that stage, they've lost the game. Because at this point, it's completely reactive to what the problem is.
Chris has just a word. I'd ask you just a word, Chris, because
Yeah.
we're coming to the end now.
Yes. I think the thing is that the point about somebody who's alcohol dependent is that the person is not able themselves to recover completely without some form of assistance. So that if there is a counselor appointed or a medical person appointed by the individual, but on the understanding that that person will do the monitoring, to my mind, the critical factor is not so much whether the disability is continuing, but whether the employee is cooperating with the treatment. If there's continued cooperation with the treatment, and obviously the basis of any scheme must be that the employer and the union presumably are entitled to be advised by the counsellor only whether there's cooperation or there cease to be cooperation with the treatment. If there's no cooperation with the treatment and the disability continues, that to my mind is the point at which it's legitimate then to terminate the employment. But if there continues to be cooperation, even although it's for a very extensive period, and that is the report of the expert who's ever doing the treating, then that's sufficient to maintain the employee's status in employment.
Are there any other questions from the floor? Not having observed any. We have one more question. This is the final question. I think we'll just have time for one response to this. Lynn, could you?
Well, I think that you've said it, and I think I said it in a more technical way simply because of the audience, but I think you've said the key, which is what business is it of the employer unless it can be shown that it's affecting the employee's ability to do the job. Well, I think that's a fair observation, because until it passes over into the ground, then it is more difficult. Of course, it's impossible to bring it under a prohibited or protected class, prohibited ground or protected class. But very simply, I think there are other reasons which will drive it. Again, that is crisis management. The response has been to fire the worker. What I think we're hearing more and more of is that there are other reasons, including safety concerns, that are driving employers to have comprehensive programs, which may or may not include testing. In my experience, I know it's different from your own, but that is not the norm. That is not the norm to have testing as the only component of a drug response policy.
I'm
Yes.
going to have to draw these proceedings to a close. I'd like to thank the panelists, and they will be available if there's a break in case you have further questions. So is there just a minute, I hand this over to you now, Lynn.
Break a bit. We'd appreciate your return as quickly as you can.